Welcome to our overview of Chapter 9, Contracts and Employment Law. Contract laws form the foundation for fair trade, and fair trade benefits everyone. Fair rules of commerce allow all persons to equitably exchange goods and services they have for goods and services they need. But commerce functions best in a stable, predictable business environment in which everyone is subject to the same fair rules designed for the common good. Good contract and employment laws help to promote stability, predictability, and economic fairness in hiring, conditions of employment, and the just resolution of disputes under the rule of law. The just rule of law, universal education of the citizenry, and fair commerce systems form the necessary foundations for prosperity and democracy. Democracy can only flourish where there is justice under the law, an educated citizenry, and a fair and prosperous economy. In contrast, injustice, ignorance, and economic disparity and poverty sow the seeds of social chaos and oppression. Just and efficacious legal, educational, and economic systems are the essential building blocks for a better future for all. Further, these foundational principles are interconnected and synergistic. Strengthening or weakening any of these will affect the others, thereby strengthening or weakening the foundations of our common democracy and prosperity. The quality of our lives and our children's futures depend on the strength of our democracy and prosperity. For these reasons, all citizens, and especially those responsible for educating other citizens, must understand the essential principles of a just and democratic economic system, including fair contract laws, fair employment laws, and their roles in a functional, stable, and fair economic system. Educators who understand these essential principles and the critically important social foundations supported by the rule of law, education, and fair commerce will be better prepared to teach these lessons to their students for everyone's future benefit and security. The strongest democracy and prosperity are found in those nations with the strongest commitments to the rule of law, education, and fair commerce. Democracy supports sustainable prosperity, and prosperity supports sustainable democracy. President Franklin D. Roosevelt famously warned, "True individual freedom cannot exist without economic security and independence. People who are hungry and out of a job are the stuff of which dictatorships are made." The legal foundation of our economic system is contract law. A contract is a legally enforceable bargain. A contract differs from an ordinary promise in that a contract can be enforced through a court of law. Everyone should strive to keep promises, of course, but promises are not legally enforceable contracts. Promises carry ethical and moral obligations, but not legal obligations. To acquire the force of law as a contract, a bargain must meet all the essential elements of a contract: valid consideration, offer, and acceptance. The essence of a contract is the agreement to exchange mutual benefits and detriments, referred to as legal consideration, or quid pro quo, in which each party considers performing their part of the promised exchange, the detriment, as the price of receiving the good or service, the benefit, from the other party. The exchange of benefits and detriments must be mutual, or there is no basis for a contract. A unilateral promise is not a contract. Something of value must be promised both ways, or there is no valid legal consideration and no basis for a contract. For example, a promise to give money to a school could only become a contract if legal consideration is exchanged both ways. A donor's promise to give money must be in exchange for something of value from the school. If a donor declared, "I will give the school $100,000, and nothing was promised in return, there is no enforceable contract because there is no valid consideration. And if the donor made if the donor made a conditional promise, such as, "I will give the school $100,000 if the new athletic stadium is named after me," these bilateral benefits and detriments could serve as valid consideration and the foundation for a contract. A valid contract requires not only mutual legal consideration as the foundation of the contract, but also a valid offer and a valid acceptance of the offer to complete the contract. A valid offer is defined by 1. Expression of present intent to contract, and 2. Definiteness of terms sufficient to describe the subject matter of the bargain. Speculation or or buying it in the future is not present, or rather speculation about buying or selling in the future is not present intent to contract. A statement such as, I've been thinking about selling my house, is not an expression of present intent to contract. Further, the statement does not sufficiently define the necessary terms of the contract, such as what house, how much property, the price and terms of the sale, etc. Without a clear and present intent to contract and an adequate definition of the terms of the contract, there is no valid offer. If there is an expression of present intent to contract and the terms of the bargain have been sufficiently defined, the offer remains open for the time stated. If the time is not stated, the offer remains open for a reasonable time based upon circumstances of the bargain and the common practice in the market. For example, where the timing of an offer is not expressly defined, an offer to sell a truckload of ripe bananas is necessarily a short-term offer that must be accepted quickly. The offer to sell a house, however, generally requires more extended time to reasonably secure necessary property inspections, a title search, financing, etc. In the absence of an express statement defining the timing of the offer, for example, the offer is valid for 30 days, in the common law system, common practices in the market govern the time the window is open to accept the offer. To form a contract, a valid offer must be met with a valid acceptance. The acceptance must, 1, mirror the terms of the offer, evidencing a meeting of the minds, and 2, be communicated while the offer is still open. A meeting of the minds exists where both parties reasonably share a common understanding concerning the necessary elements of the bargain. If the party responding to the offer changes the necessary element of the bargain in the asserted acceptance of the offer, it is generally not a valid acceptance, but is instead a counteroffer, which may be accepted or not by the other party. For example, if a distributor of playground equipment offered to sell a package of playground equipment to a school for $20,000, and the school board president responded by saying, "We accept your offer, provided that you throw in an extra slide," this conditional acceptance is not a valid acceptance at all. This is instead a counteroffer that the distributor may or may not accept. To constitute a valid acceptance, the acceptance must mirror the terms of the offer, and there must be sufficient meeting in the minds concerning the essential terms of the bargain. Most people generally enter into contracts intending to fulfill the contract. Contracts tend to go bad not because of insincere intentions at the time the contract was formed, but because of misunderstandings or changed circumstances that make it difficult or impossible for a party to subsequently fulfill the contract. If a contract is breached, however, the aggrieved party may seek to have the contract enforced by a court of law. The aggrieved party becomes the plaintiff in the contract case, and the party charged with breaching the contract becomes the defendant. In Chapter 9, we will review possible defenses available to the defendant in the contract and possible remedies available to a plaintiff. School officials regularly enter into contracts on behalf of the school for the purchase of necessary goods and services. From school facilities, buses, and supplies to teaching and custodial services, every item used by the school and every service necessary to keep the school operating must be purchased through institutional procurement or through personnel employment contracts. Personnel costs consume the bulk of the school budget. Education is a labor-intensive enterprise, and teachers and other school employees are essential to the successful operation of the school. School officials enter into employment contracts to secure these needed personnel services. Salaries and benefits are offered in exchange for necessary professional services. Hourly staff, non-certificated support personnel, and other at-will employees generally have no long-term contract or any reasonable expectation of continued employment. They can generally be dismissed at any time. Untenured teachers are offered year-to-year contracts until they acquire tenure. Untenured teachers can be let go or simply not renewed when their contracts expire. Only tenured teachers have a right to continued employment during the current contract term. They can only be dismissed based on a valid cause, and they are entitled to due process of law. Academic tenure, which is the foundation of teacher tenure, is a policy rooted in protecting academic freedom and limiting the influence of politics on the educational process. But teacher tenure also has economic and institutional benefits for schools. Tenure policies allow schools to offer the possibility of increased job security in lieu of higher salaries that may be available in the private sector to similarly qualified employees. More importantly, the faculty is the school, and tenure policies help to promote long-term faculty stability for schools. If only high-quality, productive teachers are tenured, tenure policies are a cost-free employment incentive for educational institutions, as good teachers would be retained anyway. Problems occur when tenure is granted to teachers that should not have been allowed tenure. In Chapter 9, we will review contract law, employee breach of contract, employment discrimination, employment litigation, religion, sex, or national origin as a bona fide occupational qualification, employment-related testing, affirmative action in employment, sexual harassment under Title VII, marriage and pregnancy discrimination, age discrimination, national origin discrimination, professional ethics, performance evaluations of employees, personnel files, open records and open meeting laws, labor unions and collective bargaining, and alternative dispute resolution. In summary, to acquire the force of law as a contract, a bargain must satisfy all the essential elements of a contract: valid consideration, offer, and acceptance. Different types of personnel have different types of contracts. Generally, non-certificated personnel are at-will employees with no reasonable expectation of continued employment and can be dismissed at any time. Untenured educators have property rights in their yearly contracts, but can be dismissed for cause any time or simply non-renewed at the end of the contract term. Only tenured educators have an ongoing property right to continued employment beyond the current contract term. Untenured teachers are generally not entitled to any explanation for a non-renewal. Further, an explanation for a non-renewal may create a right to due process. Tenured educators can only be dismissed for a valid cause specified in the applicable state statute. For example, proof of incompetency, insubordination, willful neglect of duties, immorality, violations of school policies or rules, reductions in force, or other good and sufficient causes allowable under state law. The establishment, due process, and equal protection clauses prohibit discrimination by government agencies based on religion, race, gender, or national origin. Title VII extended these prohibitions to the private sector. Government agencies, including public schools, are prohibited from discriminating in employment by both the Constitution and Title VII. Also prohibited are employment discrimination based on age for persons over 40 and discrimination based on disability, pregnancy, or related medical conditions. Under appropriate circumstances, however, religion, sex, or national origin may be a bona fide occupational qualification and permissible as an employment criteria under Title VII. But note that race and color are never legitimate job qualifications. Concerning the performance evaluation process, established state and local policies and due process must be strictly followed. Failure to do so may be a per se violation of due process. Personnel files must be kept in accordance with due process of law and in compliance with HIPAA, FOIA, and other applicable federal and state laws. School officials must know and comply with the laws governing public records and meetings in their state. Failure to comply with these laws may result in civil liability or criminal penalties. The National Labor Relations Act protects the rights of all private sector employees to form unions and engage in collective bargaining. State laws govern rights to collective bargaining for state employees. Even where there is no legal right to collective bargaining, public educators do retain their right to freedom of association and may join professional and political organizations. Remember that alternative dispute resolution, or ADR, may be a useful alternative to litigation. Options to ADR include informal resolutions, mediation, negotiations, and arbitration. Regarding professional ethics, Professional conduct is guided by a hierarchy of laws, ethics, and morality, with legal compliance forming the essential foundation, standards of professional ethics establishing higher professional norms, and moral ideals setting the highest aspirational goals in professional practice. In conclusion, regarding contracts and tenure, take great care in who is offered a contract and even more care in who is granted tenure. Serious personnel problems are far easier to prevent than they are to fix. In addition to objective job qualifications, always carefully assess the professional ethics and collegiality of potential employees. Even more important, do not grant tenure to employees who clearly failed tests of professional ethics and collegiality during the probationary period prior to tenure. Personnel problems rarely get better after tenure. A positive professional culture is essential to everyone's success. One rotten apple really can spoil the barrel for everyone, potentially resulting in huge losses of time and money, harms to your institutional reputation, and causing your best people to flee the bad personnel situation. To save yourself, your colleagues, and your institution, do not hire or tenure a rotten apple. Regardless of any other qualifications or other talents of the employee, deficiencies in professional ethics and collegiality make that person an unfit employee that will do far more harm than good for your institution. Regarding employment discrimination, never be a party to employment discrimination in any form. Further, take care to assure that all employment decisions are made fairly and only on the basis of valid employment criteria, and that even unconscious bias is carefully guarded against. Actively seek a diverse pool of applicants, make the employment decision based only on lawful criteria, and hire the most qualified candidate, regardless of race, color, religion, sex, national origin, disability, age, family status, or any other criteria unrelated to legitimate employment qualifications. Regarding professional ethics, compliance with the law is necessary, but it is not sufficient. Professionals hold themselves to the higher callings of professional ethics and personal morality. You will never regret doing the good and right thing, even when it's difficult at the time. There is no honor in prevailing dishonorably. Always do the right thing, and then win or lose on the issue, you will have won personal honor and self-respect. And by having a reputation for personal integrity, you will win the respect of your colleagues as well. In all cases, do what is right and treat others as you would wish to be treated. Do not allow the negative emotions of anger, fear, etc. to deter you from doing what you know is right, always choosing what is right over what is easy at the time. Regarding alternative dispute resolution, in most cases, neither party in the dispute wants to see the dispute escalate to litigation. As Sun Tzu said in The Art of War, build your enemy a golden bridge to retreat on, as the greatest victory comes from achieving your goals without the costs of battle. With some careful thought and planning, you may be able to achieve your necessary goals in a win-win scenario, thereby building rather than harming working relationships. Negotiation and mediation skills can be invaluable assets. Nonetheless, throughout the process, document and prepare to prevail in litigation if it becomes necessary. The preparation of a solid legal case will also strengthen your hand in negotiations. I hope you will enjoy your studies. Very best wishes to all.